And it's time for Marshall Law, our program segment with Marshall Chriswell. This program intended to be for informational purposes only. The information does not constitute legal advice. The law constantly changes. The information may not be complete or correct depending on the date, your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations. And because of that, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. And that leads us to Marshall Chriswell. Good morning.
Good morning.
How are you?
I'm doing well. How are you this Monday?
Wonderful. I know you've got this seminar coming up later in Hillsdale, and we'll try to get to that before we're done here today so we can invite people to it, or climber, I guess. But we've talked a lot about estate law here on these segments, and one of the segments or one of the questions folks might have is, what happens if somebody owes me money or some sort of property and they pass away? What are my legal recourses? What can I do in order to ensure that the monies or whatever it is that I'm owed, actually I get them?
Good question. Good question. And, I think, a lot of people might think, well, I'm just out of luck, right? But that's not always the case. This situation comes up with some regularity. You've got lots of different scenarios. Maybe you're an employee of a sole proprietor who passes away. They owe you your last paycheck and maybe some payout of some benefits and things like that if their business is closing or what have you. Maybe you made a loan to a friend or a family member. And they pass. Maybe you're a small business owner yourself, and you have clients, you have customers with outstanding bills, and one of them passes away. How do you get paid? So the first thing that you do, you consult with an attorney, but the first thing that I would do is you see if there's been an estate open for this person. Okay. And we've talked about on this program before that every estate is going to have an executor or an administrator, somebody that's the legally responsible person to manage the estate according to law, and that includes paying the legal debts of the estate to the extent that there are assets to pay them. So you go and first of all you check the records at the courthouse and you say, okay, has there been an estate opened? And once there's an estate opened, if you have something that's owed to you from the estate, if you have a claim against the estate, you have to first then file a legal claim against the estate, and that has to be done within a specified time period.
Okay. And of course, there will be others who might be creditors of this person as well. And so the question then becomes, okay, who gets priority? Do the monies that he's owed take priority over mine? Is it first come, first serve? How is that decided?
Yeah, and you're right on track there. A lot of estates are going to have creditors, multiple creditors, and there is actually in the code, in the statute, there is an order of priority for creditors. So you look and right up top. You've got administrative expenses of the estate, and if there's an executor that's taking a fee for their work, the attorney's fees, any expenses associated with opening the estate and managing the property of the estate, all of those things really come off the top first. Then medical bills, and it's usually medical bills that were incurred within the last 6 months of a person's life have priority over other medical bills.
Okay.
And then after medical bills, we start getting into other creditors. It's also worth noting that if there are secured creditors, such as a bank that holds a mortgage on a property or a financing company that holds a lien on a motor vehicle, things like that, secured creditors, they also take priority with respect to those assets.
So there is a system by which you're placed in line.
That's right. That's right. And then the estate administration process goes on, and what's supposed to happen is the executor or the administrator determines what all of those legal debts are, and pays them out, but only, like I said, to the extent there are probate assets to pay them. And So if there are $100,000 in creditors and only $50,000 in probate assets, then there are some decisions to be made and agreements to be reached, or you file an accounting with the court and get an approval on how you're going to pay everybody out.
And so the ones at the back of the line, in a case such as that, there's probably going to be very little available to them by the time it would get down to their level.
Yes, unsecured
It's not
creditor,
a percentage type of thing.
That's right. You may have a percentage within the same bracket. So if I have a bunch of medical bills and there aren't enough money to pay them all, we're going to need to figure out exactly, we're going to divvy that out in percentages to those different creditors. But then, as you get down the line, the last guys in line are usually the personal credit cards, your regular Visa or MasterCard, unsecured credit. That a lot of times those don't get paid out of the estate.
They're out of luck there.
Yeah.
All right. So we're talking now about people who have an estate on which they can file a claim. What about the person who is owed money? Somebody passes away. They've got no estate plan in place.
Right. So if you're owed money and you go and you look and there's been no estate open, is that
Yes.
the question? Yeah. So what you do is, so you need to determine who the next of kin are of that person, of the person who passed, and you can actually get, it's called a citation, and it's not like a citation for speeding down the highway. It's a form of a court order that's issued by the Orphans Court of the county that issues an order and says, hey, you're the next of kin of this person. We believe you may be in possession of that person's last will and testament. You have an obligation to come and open an estate for this person. It's a court order for them to show up and say, I'll open an estate to get creditors paid, or I don't have possession of this will, or for some other reason can't do it. So that's your next recourse, is to try to find the person who would be legally responsible for taking care of these matters. And if you can't find, and if that doesn't work, as a creditor of an estate, you can actually open an estate for someone.
Oh,
and
okay.
I've done that before. Represented a creditor, and there's no next of kin or nothing, that doesn't work out. So you go in and you actually open an estate for the deceased person for the purpose of getting your bill paid. Mm-hmm. So that's a possibility as well.
Yeah. In all of those sound like that's not something you're going to try off the internet. You need an attorney that's going to represent you.
100%. You absolutely do. So if this was a loan for, $100 or something like that, sometimes it's maybe not worth pursuing. Right.
Yeah.
But you do almost certainly have to have an attorney. Because the procedures, the rules of the Orphans Court, which are the procedural rules you go by in these matters, are really sticky, and you've got to follow them to the letter.
And for the person we were just talking about, who is the beneficiary of the last will and testament, or somehow has come into possession of the properties or the finances of someone who has passed away, they certainly need an attorney to represent them. That's not something they want to try to figure out on their own.
Right. And I think I've said this before. I spend almost as much time, dealing with opening estates and things as I do dealing with problems, fixing problems from folks that tried to do things on their own, like opening a estate and dealing with creditors and things like that. A lot of people try to go that on their own, and usually you get a little ways down that road and you realize, wait a minute, I'm in way over my head. I just don't know what I'm doing here.
Yeah, it's like on the TV commercials, the professional, do not try this on your own.
Right.
All right, I want to talk about this event that you were telling me about that's going to be happening. Where, when, and who can go, and what are you going to be talking about?
Sure. So this is going to be this coming Tuesday, the 5th, at 6 o'clock in the evening. It's at the in the Clymer Church of the Resurrection Administration Building, which is on Morris Street in Clymer. I think it's 259 Morris Street, if I remember correctly off the top of my head. And this is an event that's being put on by the Hillsdale Aristocare, the Hillsdale Personal Care Home, and it is part of their Alzheimer's support group. Mm-hmm. So this is a basic estate planning seminar. And I'm sure it'll be led by audience questions in a lot of respects. So I'm sure that we will be discussing quite a bit about estate planning with respect to incapacitated individuals
Sure.
or folks that have received an Alzheimer's diagnosis, things like that. But the information I'm going to present is also going to be applicable to anybody's situation. So, and it's going to be those basic concepts of, what are the documents that I need to put in place in order to ensure that my affairs can be handled correctly and that my loved ones don't have a lot of things to worry about whenever I'm no longer here. There's things that we've harped on this show before. Making sure you have a will, a financial power of attorney, a healthcare power of attorney, a living will. And what are all the intricacies in drafting those that we need to deal with, and then also planning for how assets are going to pass to your intended beneficiaries, and minimizing the effect of taxes and creditor claims and things like that.
Mm-hmm. So anybody can come.
Anybody can come.
No charge.
That's right, and I believe there are going to be some refreshments provided by the hosts, and no charge. Free, open to the public. Come on out for an hour or so and learn a little bit about estate planning.
Next Tuesday. Give the site again.
It is Tuesday the 5th, 6 p.m. At the Church of the Resurrection Administration Center in Clymer.
All right. I could see somebody who is maybe in my boat. You're getting to the point where you're really starting to think seriously, what happens to me should something mentally occur for me in the next 15 or 20 years. So do I need to get that in place? The children who are already finding themselves in that boat of having to deal with someone who might not have had that in place, it'd be really good for them too.
It is, and that's something that I'm sure I'll be talking about is, what happens if you are down this road and you don't put those plans in place, and what are the consequences there? What might you have to do as a child or a caretaker in order to be able to care for someone when they're incapacitated? Talking about guardianship actions and the inheritance expense and hassle that is and things. So I think it's going to be a really good discussion, and I'd encourage folks to come out.
All right. Meanwhile, people want to use your services. What do they need to do?
Get in touch with me by phone, 724-465-5826. Stop and see me in the Atrium Building, downtown Indiana, or go online to westernpalawyer.com.
He is Marshall Chriswell. Thanks so much.
Thank you, sir.
It's the voice of Indiana County, WCCS, AM 1160 and 101.1 FM.